Sorry.
I'm on trying to figure out how we articulate this, okay? You've come in with the simple proposition that ordinary contract principles defenses should generally apply. There
Same
might be
standard the government has.
The same standard the government has. And that's not just frustration of purpose, because frustration of purpose means both a procedural and substantive component. And you may not have a procedural component in this kind of waiver. But I think the other defense are public policy. It's against public policy. That's the rationale for statutory maximums, which is Congress has said you should only receive a sentence of X amount, okay?
Yeah, and there's separation of powers issues.
Exactly.
Yeah. I think it depends on your comfort level with those two words.
Right.
A lot of people freak out at that word. I don't.
I
because
know, but I don't either. And the implied duty of good faith, that has to do with the judge doing what he's supposed to do. And that subsumes unconscionability, that subsumes clear error, it subsumes constitutional error.
And is a heavy thumb on the implied party's expectation that the contract would be enforced. So what I think, what the government, the scare tactics, they sound really broad. They're not, because if you just read one Delaware case, it'll tell you the implied covenant of good faith has to mean.
Let me just stop you on all of this discussion.
Okay.
Arizona, Minnesota, California, and Texas, all of their high courts say that a prospective waiver of a not yet imposed sentence is not enforceable. All right? When the defendant does not know what errors, if any, that there could be. Because they're not giving up a right.
An unknown.
Unknown right. You haven't argued that. It may be too much water under the bridge. But there is a strong argument, by the way, and it goes back to something that Justice Gorsuch was referring to on the sentencing guidelines. The reports when the guidelines came out said we're permitting appeal waivers because appellate review of sentencing is essential to ensure that the guidelines are applied properly and to provide case law development of the reasons for sentencing outside the guidelines.
Yeah, guideline errors are just going to be out, and they've been
I know, but don't give up so easily. Okay?
Let me just break it down.
Let me just come
Oh, sure. Yeah,
let me finish my question, okay?
Yeah, I'm sorry.
I know you want to correct me along the way, but...
No, it's wonderful what you're saying. Keep going.
The reason why Justice Alito's arguments about trial errors doesn't work is because you are giving up some known defenses to a trial. You can look at all of those things, you can imagine them, and you can say, whatever they are, I'm going to give them up. So those are never considered, the trial-related errors. What we're talking about is sentencing errors, which is at a time where you don't know what the judge is going to do. And so you have to make certain presumptions. One of them is they're not going to act outside of their constitutional or statutory duty. That's your argument, isn't it?
Yeah, I can tell you, I did think about what you said, because you can make an argument like in all your cases, Mezzanotto is the best one that explains what you can waive. And basically, personal rights, this goes to Justice Alito, personal rights can be waived. Now, you get to a certain point where there's a public interest in the actual right. And what we are trying to say, when courts go so outside the bounds of what anyone could have been thinking, government can't even defend it, it's implausible. There's something to be said for the criminal justice system not bringing itself into disrepute and having these embarrassing sentences out there, and the judiciary has certainly the authority or duty to correct them. So you can analyze it under Mezzanotto, but it just seemed like a higher hill to climb.
Thank you.